Meg Tippett, how are you doing today?
I am good. How are you?
I'm doing great, thank you very much.
Hmm.
So we have several cases we're going to go over today. I think five. We're going to try to dive right on in here and get into them. So I want to talk to you about Maryland National Bank versus United Jewish Appeal Federation of Greater Washington. Let's just kind of hop right on in, and maybe you can tell us kind of who are the parties here, and kind of how did this case get to this court?
Sure. Okay. So the plaintiff was the United Jewish Appeal Federation, and the defendant is Milton Pullinger, but he's represented by Maryland National Bank.
Okay. So let me stop you there for just a second, right? So you said that um, the United Jewish Appeal Federation was the plaintiff. Is that right? Did I get
Yes,
that? Did I get it right, or did I get it backwards?
that's what I said.
Okay, no, that's fine. Um,
Okay.
so I'm going to ask you a follow-up question, which is there a plaintiff in this case?
Um, I guess not.
so so what I think you are doing is reading into my tone, right?
Hmm.
And you think that I'm leading you to say that there's not, but I just want to focus kind of let's focus on the procedural history, and then maybe that'll help us answer the question. So why don't you
Okay.
talk to us a little bit about how this case kind of got to the Court of Appeals of Maryland?
All
Where
right.
did it start, and what was the path it took?
Sure. So my understanding of it is that the United Jewish Appeal filed a petition hoping that the money would be paid, and this was sent to summary judgment.
Okay, so I think you're right that there was a petition by UJA, uh, but I wonder if that was the first thing that happened in this case. What's
Um,
the first procedural thing that happens here? So if you're looking at the opinion, maybe look at that very first section with the Roman numeral 1 there. I would even look at the third sentence of that to maybe kind of get us pointed in the right direction here.
okay. Um, that uh, I mean, I all I have, I guess, is that they filed a claim, and this it was moved. I mean, that's just what I said.
Okay, no, that's fine. So, do you have the opinion in front of you?
Yes.
Okay, so literally look at the very first page of the opinion, and I want you to go to Roman numeral 1. You're with me so far?
Yes.
Okay, and then I want you to read the third sentence of that paragraph. It begins, his last will.
Right. Okay. His last will and testament was admitted to probate in the Orphans Court for Montgomery County, and letters were issued to Melvin R. Oskner and Maryland National Bank as personal representatives.
Okay, so let's focus right there for a second. So this is actually the beginning of the procedure in this case, right? And so what's important to recognize in context here, right, and this will cause us to dig a little bit into the facts, right? But so there's this person, right, Milton Pollinger, right, who has made a pledge of $200,000 to what this court is calling UJA, right? And he dies, right, before that pledge is fulfilled.
Right.
And so the first thing that happens, right, is when someone dies, if they have an estate, right, that estate goes to probate, right, and a court is responsible then for distributing the assets of that estate, right, and so that's kind of the first thing that's happening, and then then when the probate court kind of gets charge of the case, it will generally, right, appoint someone to act kind of on behalf of the estate, right, to receive claims against the estate and to then approve or deny those claims, right? So here we see that there's a Melvin R. Oxner and Maryland National Bank, right, who are named personal representatives, right? So that's step number 2 in our procedural history here, right? And so this explains then ultimately why Maryland National Bank is a party to this case, right? Is a party to this appeal, right? They're really behaving in their capacity as a personal representative of the estate, right? Um,
Right.
they don't have they're not independently, right, going to be giving up their own money here, right? But the question is really whether UJA is entitled to money from the estate. And so it is their job as a personal representative of the estate to either approve or deny those claims. So then we get to where you are, right? So, well, close to where you are, right? So what happens kind of before this petition by UJA is that there are claims made, right? So people make claims against the estate, right? Contacting the personal representative saying, I make this claim, and then the personal representatives say, I approve or I disapprove, right? If they disapprove, then we can see here in terms of the procedure, the person whose claim is, in the words of the opinion here, disallowed, right, is that person then may file a petition to the court, right? So we start out with like a private entity as the personal representative making a decision, no, your claim is not allowed, right? Then we get to a point, once that is disallowed, that UJA files a petition. And so what I really want to make clear here is that they're not really a plaintiff, right? They are a party that is moving through a petition to be included within the claim, right? That their claim be allowed, but it's really more like a motion, right? We are seeking to ensure that our claim can be considered as a part of this probate proceeding. Right, and so that's kind of where we are. So when we kind of think of it here, we're really not really thinking of either of these parties as a plaintiff or a defendant, right? There's really more of a petitioner-respondent kind of idea, even at the trial or orphans court level. So I'm going to let you pick it back up from here, right? So there has been a petition by UJA, right, and they also move for summary judgment. What happens next?
So the representatives then filed a cross motion rejecting the payment that they were asking for. And then the UJA filed against them, and the defendants, or not the defendants, the representatives appealed to the Court of Special Appeals of Maryland and petitioned for a right of certiorari.
Certiorari.
Sorry, certiorari.
Yes.
Okay.
Yes. So you will hear people pronounce that word differently. I think certiorari is probably the most common pronunciation of that word. You'll hear some people say like certiorari, but that ignores like the R in the middle of the word. So I favor certiorari. You will hear this a lot. You will also often hear to it as cert. This a petition for a writ of cert or a writ of certiorari is something that happens in different procedures at an appellate level. It's basically a request to be heard, right? This is a case where I do not have a right to appeal directly to this court, but I have the ability to ask this court to take up my case. Many, if not most cases, I'm reluctant to say all because I think there are cases that can be taken to the Supreme Court as of right, but this is where we're just going to like acknowledge my deficiencies as a Supreme Court expert. But most cases, at least, that go to the Supreme Court of the United States get there by way of a writ of certiorari, right? So there is the parties who lose at the Court of Appeals level will ask the Supreme Court to hear their case. And the Supreme Court will make a decision whether or not this is the kind of case that they want to hear. The Supreme Court may decide that the issue hasn't been vetted enough at the Court of Appeals level for them to take it up, or the court may decide that it is just important enough, that it's just important enough for the court to deal with it as an initial matter. So what you see here then is that there is a simultaneous appeal to the Court of Special Appeals and a petition to the Court of Appeals, which is the High Court in Maryland, right, to hear this appeal directly, right? And so that's what happens. And so instead of this going through the Court of Special Appeals, this ends up going right to the Court of Appeals through this writ of certiorari. Okay.
Right.
So the Court of Appeals grants that writ, that petition for a writ. And so here we are now before the Court of Appeals of Maryland. So tell me a little bit about the facts of this case. Like, what are the important facts here?
Sure. So Milton Pollinger pledged a specific amount, $200,000 to the UJA, and he wrote this pledge in 1974 saying that he would pay them, but it was used as kind of like a campaign drive to garner other donations from other wealthy people.
Right.
So when the UJA receives pledges, they kind of make like an estimation about the money that they will receive and then make decisions based off of that estimate. So in this case, they decided to help build an anthem. And so when their pledges had reached a specific amount, they decided to start building it.
Okay.
And the problem is that he did not make the payment because he died. So they're looking to get the money back because they spent it already.
Okay. So thank you. It's very helpful. I just want to observe something here that I don't think we've seen before. And on kind of on this page where we're kind of at the end of the facts, the end of like Roman numeral 2 of this opinion, you'll see that last paragraph that begins with a bracket and then Pollinger's pledge. You see that? Does everybody see that? So you see that bracket that goes all the way around that paragraph and then the ellipses that's below that. So what the bracket is going to tell you is that the author, right, the editor of this book or the case book has summarized for you facts that are in the opinion, right? So has determined, on whatever basis that there's just so much going on there that they don't really think it's important for you to see it. They've summarized what they believe is important. The ellipses will show you that certain information has been cut out altogether. Sometimes you will see that some claims are just cut out because they're not relevant to whatever you happen to be studying at the moment. So I just wanted to observe that kind of visual cue that will tell you kind of what's going on. Thank you very much for kind of the factual description. I want to, let's walk through how do we analyze this? Do we analyze like this we kind of have this new idea in this case and a couple of the upcoming cases about either charitable pledges or subscriptions to charitable organizations. And I wonder if you think the rule that we've been applying for promissory estoppel is the same rule that we would apply to resolve questions relating to charitable pledges.
So do you mean to discuss the ruling that they referred to?
So we've been talking generally about versions of Restatement Second, Section 90, right?
Right.
And so we've been looking kind of as we have parsed out this rule. I think we've been looking at a promise that where reliance is foreseeable, that actual reliance occurs, that reliance is reasonable, and that justice then requires enforcement. And so what I'm asking you is, do you think that this court is uh, using that same theory with respect to a charitable pledge, or is it using a different theory?
I thought it was using the same theory that we've been looking at.
I think you're right. Yeah, and so tell me where you see that.
So they state, or they quote the restatement of contract section 90 and the definition of the promise in the third Roman numeral,
Yes.
and then explain how that they had the payment was obligatory because the expenses were incurred by others, so that they had already spent it on something else.
So they reference several earlier cases, right? Giddings, Erdman, Sterling, and American University, and then they talk about all of those four cases, right? And so
Mm-hmm.
what the Court of Appeals of Maryland is doing is showing us the history of the development of this doctrine in Maryland, right? So they go back to Giddings. If you kind of go to there's another large indented paragraph that begins with "in whatever certain uncertainty." You all see that, and then right below that, there's a sentence that says, below that quote, there's a sentence that says, "The statement of law." This statement of the law appeared to be obiter dictum. Does everybody see that language? I just wanted to kind of point it out to you. This is when we talked, I don't recall now if it was yesterday, the day before, I talked to you a little bit about dictum, about dicta, right? And so this is what uh, what this court is referring to, right? Obiter dictum being again, language that is not essential to the ruling in a particular case, but may give some guidance. And so the court observes that there's this dictum in Giddings that becomes the law in Erdman, right? And then we see in later cases kind of how that rule is applied. So what's the essential idea of what we need to show in order to enforce a charitable pledge, Ms. Tippett?
That it was a promise that was made, that there was intent, and then that they relied on the promise.
Okay, so let's take those pieces. First, was there a promise?
So there was a promise, but they didn't consider it to be reasonable because it was brought about as like a campaign drive for other promises to be made.
So I'm not sure I'm understanding. Like, why don't you point me to kind of what you are looking at to conclude that they don't really think it's a legit promise?
Um,
That's what I'm paraphrasing what you said, but
so they say the promise was not legally enforceable. There was no consideration as required by contract law.
okay. So that tells me that the promise isn't enforceable, but it
Mm-hmm.
seems to indicate to me that there was indeed a promise.
Okay. Yeah. Yeah. Okay. Yeah.
Right?
Yeah.
So if we're looking at kind of our first element here, I think then we understand that there is a promise. What is the promise?
That he would pay $100,000.
Yeah, and in fact, what did he say? Right? He says, if we look back in section 2 of this opinion, in consideration of the obligation incurred based upon this pledge, I hereby promise, right, to pay UJA the amount indicated on this card, right? So
Right.
we've talked a good deal, I think, so far about the idea of understandings between parties and kind of this follow-up action, right, that seems to reinforce words that have been said. And so I think one way that this case probably helps us is to show us that a promise can happen in one moment, right, and be just a really clear and definitive statement, right? And so while we have seen cases where we see some follow-up conduct that reinforces what might be a promise or what might be an idea or a statement of intention, We can also simply get a promise just by clearly articulated words. Right? I think that's an important point for us to make sure that um, we get across here. Okay, so we have a promise. Is reliance in this case, do you think, foreseeable?
So from how I understood, the UGA or UJA accepts money and then kind of disperses that across different organizations as they see fit. So the reliance was kind of in question because they, how am I going to word this? They technically, he wasn't paying for a specific thing. He wasn't paying towards the specific building that they had built based off of his pledge, but instead he was just donating just generally to them.
Okay, so we do understand that UJA's practice, right, is to take in pledges, and then based on the pledges they get, right, they allocate resources to other organizations, right? They say, we'll give, this much to you, this much to you. And that is, I think, it seems, at least from the opinion, like dependent nearly entirely upon the pledges that are made, right? Do you have a sense for how much, like when they get pledges, how much they actually end up collecting?
They said that they have, I think it was this case, that they sometimes don't, they don't always get everything that they have been pledged.
Okay.
That they make allowance for that usually because in the past they haven't received every dollar that has been pledged to them.
Right, and in this case, it says historically they get 95% of the pledges are collected, and they make an allowance for the 5%, just as you've said, right? So, do you think, not so much what does the court think here, but do you think that reflects reliance when UJA looks at the pledges that it's taken in and says, okay, based on this information, we are going to allocate resources now to these other organizations?
So I would say yes, because there's a promise that was made, and then his intent by signing the card, sending it in, and then they're therefore relying on his payment to build or pay for whatever that they need.
And so the kind of standard that the courts really end up looking at in a lot of these cases is whether there's some kind of material change in position, right? Like, can you argue that they do materially change their position in reliance on that promise?
Right. Can I argue that?
That's correct, yes.
Oh,
Can you argue it?
No, I wouldn't argue that.
Okay, so what would you argue?
I would argue that they knew that this could happen. This has happened to them before,
Okay.
So there's nothing that would make them believe that this could be possibly any different.
Okay, so that is what you. So what I understand then is that's what you're thinking, that they know they can't depend on all of this money coming in, so therefore they can't rely on it. Is that what I'm hearing you say? Okay. So I guess I wonder, right? Let's imagine that this is going to be a terrible example, but I'm making it up off the top of my head here. Let's imagine that you and I are good friends, right? And you are, having you have some creditors that are kind of beating down your door, and I tell you, well, I'm going to, I will give you some money, right? And in light of my promise to give you money, you take resources you already have, right, and you allocate them to pay your creditors. That makes sense, right? So you say to your creditor, you send $100 here, $1,000 there, $1,500 there, knowing that I'm going to give you some chunk of money, right, or believing that I am. Do you think that in that moment you have relied on my promise?
I mean, it depends on like how much money I have myself, and
so presumably here, right, you have let's imagine, let's try to make it easy. You have 5 creditors whom you owe $2,000 apiece. You have $10,000 in the bank, right? But that is also, because you're a full-time student, that's money that you're planning to use for rent and other purposes, right?
Okay.
So when I tell you I'm going to give you $10,000, you take money out of your bank and you, instead of saving that $10,000 and using it for rent, you send it to your creditors. Now your bank balance is zero, right?
Mm-hmm.
So you've paid with your own money, you've paid your creditors, but now you have a bank balance of zero. Do you think that you have relied on my promise?
Yes.
Why?
Because now I'm broke and have no money, and I was hoping that you would pay for it.
Okay, so the absence of resources, right? The fact that you liquidated your resources,
Right.
right, in order to pay your creditors is something that made a difference here. You don't have as many resources as you would have, right?
Right.
What if you had $20,000 in the bank and you took 10 of that to pay your creditors, and now you only have $10,000 left in your account, which you can use to pay your rent? Do you think that you have relied on my promise?
I mean, it's still a detriment to me
Right?
now that I'm in debt, or nearly.
Yeah, I mean, what it has done, right, is it's depleted your resources to some degree, right?
Right.
I've caused your resources to diminish, right? Um, so then I guess my question is, how is this UJA case different, right? So it has a bank account. It has money in that bank account. It depends on the resources that are pledged to it to make allocations to organizations, right? And it says we're going to send this much that way. And in fact, what they say is they always pay the allocated amount, right? So they're
Right.
going to pay it whether they get the money or not. But at the end of the day, they have less resources, right? Less financial resources than they would if the promise had been kept. Don't you think that that is a detriment, or that's reliance?
Yes.
So have I changed your mind?
Yes.
Okay, okay, all right. So how is it that the court kind of seems to reach a different conclusion?
So they say that the promise wasn't enforceable, because that they shouldn't have used money that they didn't have already to make build something, or
So
yeah.
does the court make that as a judgment, or does the court say instead that because this is just a general pledge, that it's not tied to anything, that they can't, that they can't demonstrate reliance? Does my question make sense?
Sorry, you cut out a little bit on my internet, so I did not hear
Okay,
it.
so let me try it again. So I think what I heard you say is that the court had made some kind of judgment on what UJA did with the funds, not before they had them kind of in their hands, right? Am I paraphrasing effectively?
Yes.
Okay. So what I'm asking you though is that really what the court is saying, or is the court saying instead that that the pledge that was made wasn't specific to any particular thing you were doing, right? And as a result, you can't show that you relied on this particular promise to do any particular thing, or that you suffered any particular detriment.
Right.
So you think that's more what the court is saying?
I think their point was that there was no because the pledge was not for anything specific, as you said. They didn't. There was no change in their position depending on whether or not they received the pledge or not.
All right. In fact, the court says that in part 5 of their opinion, no release was given or binding agreement made by UJA on the strength of Pollinger's pledge, right? So there's nothing that they can really tie it to. And even later in that paragraph, this is the big first paragraph of section 5 of the opinion. The court says this quote here: "There was no change shown in the position of UJA made in reliance on the subscription, which resulted in an economic loss. And in fact, there was no such loss demonstrated." And so I think I'll just ask this rhetorically. You don't have to answer this, but here it seems to me the court is saying there's no loss, right? There's no harm here, and I'm wondering if that's fair, right? Doesn't the fact that it kept its obligations, right? It kept it allocated resources and kept those obligations to allocate those resources mean that it has less in savings, and isn't that a tangible economic loss, right? That's the question that I have. I want to observe a couple of things from this opinion because I do think that it is useful for us to point them out here. One is that, and this is back now in, let's see, section 3 of the opinion. There's that second big indented quote in section 3 of the opinion. That paragraph that I actually started reading that says, "In whatever certainty," it says, "in whatever uncertainty, rather, the law concerning voluntary subscriptions of this character may be at this time, ... I just want to observe that this court is recognizing that there is some dispute among courts at this time about how to deal with charitable subscriptions. I think we see some of that discussion in later cases as well, right? But some courts really favor enforcing charitable subscriptions so that they either will kind of go out of their way to find consideration to support that promise, or on the other hand, they may simply say that they will enforce it notwithstanding the necessity for reliance in that case. The other thing that I would like you to observe is kind of in the middle of section 4 of the opinion. There's a paragraph that begins cases throughout the country. I guess if you're going from the end of section 4, it's 1, 2, 3, 4 paragraphs from the end. So I don't know if, can you all see that paragraph? Again, it begins cases throughout the country. In the middle of that, there's this reference to Williston on contracts. I don't know if you see that. That's maybe 8 or 10 lines down. There's just a quote to Williston on contracts. I just want you to just note that source, that resource. So there are two major legal minds who have contributed over history to the understanding and law of contracts. One is Williston. And so when you see kind of courts referring to Williston, just know that Williston is one of those two leading minds in contract law. The other is someone named Corbin. So there's Williston and Corbin. Williston and Corbin, Corbin is Corbin. So Williston and Corbin may have different views on things, but so we might see a Willistonian approach to something in contract law. We might see a Corbinian approach to some things in contract law. I just wanted you to observe the name because these are names. Those two names are names that'll pop up for you throughout your study of contract law, at least. And so it's just useful to know what they are, so that you're kind of recognizing them in context. All right, so I just want to make one last observation about this case, and then we'll move on to the next one, right? So in the next to last real paragraph of the opinion, sorry, does somebody have a question?
Yes.
Oh, sure, sorry, please, go ahead.
So in this case, apparently the person, Milton, has died, right? I saw a lot of contract, even if it's binding, they would have some consideration if the person died, would they end the contract, or it won't consider as a breach of the contract, right?
So Sorry, so if I'm understanding the question right, then the question is a contract enforceable after a person dies, right?
Yes.
And so I think the answer depends on the nature of the contract. So, for example, if you and I have a contract for me to paint your house,
Mm-hmm.
right, in exchange for a sum of money, and I die, you can't force anybody to paint your house, right? On the
Yeah.
other hand, if there's a contract, that entitles you to some payment of money, then you would have a claim against my estate, right? That while
Mm-hmm.
my estate is kind of standing there in my stead, right? And it's there. This is my money, and it is there in the first instance to pay off my obligations,
Okay.
right? So
Yeah.
creditors would come after it, right? And whoever else might have an entitlement to that. And so the answer is yes, right? There are contracts that are enforceable even though the person who made the promise has died,
Okay.
right? And so here we're looking at that exact situation, right? So I think it um, sorry, I've already forgotten his name now. Had Mr. Milton Pollinger not died, then the chances are probably good that he would have performed, right? I do think it's useful at least to think about um, whether um, whether Pollinger could have reneged on this contract if he had remained alive, right? Is there a difference because it's his estate kind of pushing this forward? I think we'll ask the same question in a couple of minutes on the King case, because I think that same question I think is relevant to that opinion as well. So did I respond to your question? Is that
It responds my question, but I have a following question. Is
by
that
all
if,
means?
in this case, will the outcome changes if he just changed his mind instead of died?
So I think that is the question. I think I would, as we look at this case, it appears that the court has said that this is simply a gratuitous promise, right? In which case that means it's not enforceable under contract law, right?
Uh-huh.
That's the point. The court's saying here it's not enforceable. There's no legal consideration for it. It's just a promise. It's just a gift. It's a promise of a gift. It's a gratuitous promise. There's no reliance or consideration to support that promise, and as a result, it's not enforceable under contract law, is what this court is
Okay.
saying. So I actually don't think this court would really make a different decision if Milton Pollinger had simply changed his mind. I think the court would have made the same decision. Now, this is based on the analysis the court performs here. And, the Maryland courts, like all courts, are very considerate and do their best to apply the law. But I do think that, that judges and justices are human beings and
Mm-hmm.
also may be influenced by circumstances, by what kind of seems like the morally appropriate outcome, and so I think to the extent that that can help them um, uh, determine which of two alternatives seems like the better alternatives, that perhaps that sometimes, even though it's not in the text of the opinion, might inform them, right, to some degree. Um, I'm not suggesting that happened here. I think that I've told you before, I'm kind of a cynic, right? And so I really do think that as we look at jurisprudence, we can't just look at the words that judges or justices use. That surely there are other things that are influencing their decision making, right? Um, uh, and so we yeah, but in any event, in this case, based on the law the court is presenting to us, I would expect that it would reach the same result. Um, it would be interesting to think about whether they would, if they're faced with this living man who has made this promise and has started performing on it, and then just suddenly reneges on that promise, whether they'd have the same kind of emotional reaction to that set of facts being slightly different, right? Because it might
Mm-hmm.
have a different kind of moral influence on them. All right, so let's go on to In re Morton Shoe Company. Ms. Tippett, thank you very much for your help. Oh, sorry, Pauline, yes.
I guess it might actually be more of a comment, but to me this case it kind of struck me that the charitable organization was being punished for for making its allocations based on what it collected and not just what it was pledged. Because in the later, one of the other cases that we read for this reading, they ruled in favor of the charitable organization. So I don't know, I guess.
So I let's maybe explore this a little more factually, right? Because I think maybe your premise isn't entirely right, because they actually make their allocations based on the pledges, not on what they've collected.
Okay.
Right? As I understand it, right? I'm reading from section 2 of the opinion where it says, in other words, UJA makes allocations to the various beneficiary organizations based upon pledges made to it, right? And those organizations incur liabilities based on the allocations. Does that make sense? So
yeah, I don't know. Sorry.
No, that's okay. I think your premise might be wrong based on my reading of the facts.
Yeah, then maybe I just don't know where I'm getting that from, because I had written down that the UGA's practice to pay over what was collected, not what was pledged, so no action or forbearance of a definite and substantial character resulted. But I don't know now where I got that, so maybe I just...
Okay, so I mean, it might be useful to find it so we can kind of try to put that in context. As I look at the facts, again, I'm just looking at section 2 of the opinion right now. That same paragraph, right? They say that they always pay the allocated amount, and it seems like they do it without regard to whether they actually collect it all or not. In fact, they don't always collect it all. Go ahead.
I think I found it. I think it's in the section 5.
Okay.
That first big chunk. It says UGA practice. It's a bit different.
Sorry.
UGA practice.
I see that. So that is a slightly different thing that the court is talking about here.
Okay.
So the $200,000 that was pledged by Bollinger, right, 100,000 of it was to go straight to UGA. Another of it was kind of earmarked, right, to go to the Israel Emergency Fund. Mm-hmm. You with me, right? And so I think what this is saying is that in terms of the money that's earmarked, they only pay that money to the fund if that money is collected.
Okay.
So I think that's a slightly different practice. So we might, so maybe there's a slightly different way to look at each $100,000, perhaps. Does that help?
Yeah, that clears it up.
Okay, great, thank you. All right, so in Ray Morton Shoe Company, it is 2:23. I think I'd like to power through this case, then we'll take a break, okay? I think this one may go a little bit more quickly. Anyway, so let's see. Priyanka Shah, how are you doing today?
I'm good. How are you?
I'm doing great. So why don't you tell us a little bit about N. Ray Morton Shoe Company? Like who's involved here and how did the case get to this court?
Okay. So I had the plaintiffs were the CJP, and the defendants were the Morton Shoe Company.
Okay.
So the plaintiffs filed a proof of claim for $20,000 to obtain the pledges that the defendant had made. That summed $10,000 in 1979 and $10,000 in 1980. The defendants objected. They said that the claim was not enforceable because it was a promise made without consideration. And then after the parties agreed to the facts, the case was heard in an oral argument, and it says a memoranda of law in the U.S. Bankruptcy Courts of Massachusetts.
Okay, so I'm going to ask you the same question I asked at the beginning of the last discussion. So I think you referred to, I can't remember to whom you referred to as the plaintiff. Whom did you call the plaintiff here?
I said the CJP.
Okay, the CJP. So is CJP indeed a plaintiff in this case?
I guess not, because they...
I feel like when I ask a question like that, like immediately you just think I must be trying to undermine you in some way, right? So I would say let's look at this and see, like, do we see the word plaintiff anywhere in here or defendant? I mean, you don't have to read the whole opinion, but so let's just kind of think about what court are we in here? Are we in an
The
are we in
bankruptcy.
an appellate court here?
I believe so.
Why? Why do you believe that?
Because oh no, it's I don't believe that.
Okay, why not?
Because it says it's the bankruptcy court and they filed a claim based on they were just attempting to get the 20,000 back.
So how do you have an understanding of what bankruptcy court is like, or what happens in bankruptcy court generally?
Not really.
Okay.
No.
So it's probably useful for us to just talk about that. There's some similarities actually between what we talked about with the orphans court or kind of probate court and what we were looking at here in bankruptcy court. I mean, there's many differences, but there's some overlapping similarity, right? So in bankruptcy court, a party files for bankruptcy, right? And it files for bankruptcy seeking to have its obligations modified in some way. So this is in, I think, 1984. I don't actually recall let's see. Does it tell us what chapter was filed? I don't know if it tells us what chapter of bankruptcy was filed here, but in the 1980s, this is before a pretty massive revision in bankruptcy law that occurred in the early 2000s, early 20-aughts. But the parties would go to bankruptcy to basically eradicate their debts, right? To kind of get a fresh start. The idea would be to kind of wipe out debts, wipe out obligations, and to have the opportunity to stay in business. There might be kind of reorganizations or restructurings that are involved. So what happens is that you have the debtor. The debtor is in bankruptcy court. There are all of the creditors are identified and get notice of the bankruptcy proceeding, and then those creditors have an opportunity to present their claim against whatever kind of assets are available, right? And so this is all managed by the bankruptcy court. There's sometimes a trustee in bankruptcy who's appointed. So the idea here, right, is that there is that in Morton Shoe Company, right? And this is note the title here. It's not even there's no like Morton Shoe Company versus anything, right? It's just in re, which means kind of the matter of or regarding this one entity, right? And so bankruptcy proceedings don't have plaintiffs and defendants, right? There's just kind of the bankruptcy, the debtor, bankruptcy debtor. Then a number of creditors will kind of try to stake out their claim for to recover some or a portion of what they believe they're entitled to through the bankruptcy proceeding. So here, what is happening then is that the shoe company has filed for bankruptcy. The CJP has presented a claim as a creditor in the bankruptcy proceeding. Right. And again, because it's also important to recognize this isn't a case where it's gone through a whole lot of procedure and now is on appeal. Right. This is actually a decision by the bankruptcy judge. Right. You may notice that it's written in kind of first person at a couple of points. Like it says at the end of that first paragraph, I find and rule as follows, as opposed to we, right, conclude or something like that. So it is literally written right from the perspective of a single bankruptcy judge in the District of Massachusetts. So that said, then kind of what happens with the claim here?
So, so it says CJP is the charity. They solicit pledges. They have certain meetings where it's created to get their pledges by corporate contributors.
Mm-hmm.
And they also describe the purpose and the needs of the charity. And then a pledge card can be made for those who want to pledge donations.
Right.
And then the card notes that the subscription is in consideration of the pledges of others. And then the CJP they create an operating budget and determine their beneficiaries.
Mm-hmm.
And they also hire personnel based on the pledges that they receive.
Right.
And then based on those donations pledged, they borrow the money from banks so that they can make direct donations to their recipients before they even obtain the pledge donations.
All right. So let me just interrupt you for just a second and ask you, how is, if it is, this case meaningfully different from the previous case that we just discussed?
So for this one, it's you can see that they incur a detriment based on their reliance of the pledges that were made. So they actually borrow money. So they take money from a bank based on them believing that they will receive the money back.
Okay.
And then they give that money away to their recipients. And so now they have borrowed this money that they cannot get back unless they receive it back from the pledge, which I think in the case before this, it didn't say that they borrowed money from a bank. They just used what they have collected to give out to their beneficiaries.
Is that a meaningful factual difference, do you think?
I believe so, because it shows a very clear detriment, or a very clear, it just shows that they actually lost out on the money, and if they don't get that money back, then they will suffer a loss.
So so maybe the question I have for you then is, if you view this kind of taking out the loan as a different thing, right, than using your own money, why mention all this other stuff about establishing an operating budget, determining the amount of distributions, hiring personnel? Like, why mention all the rest of that stuff if that's not, because that doesn't seem to you, at least to me, it doesn't sound like that's making the difference for you. Those sound like they're the same as the previous case.
I think that also matters a little bit, because when they create the operating budget, they're creating it based on what they think they're going to receive. And when they are going to determine who and how much people are going to receive, they base that off of the pledges that were made. And they do this all because... Okay.
Isn't that exactly what UJA was doing, though? Right? They get the pledges and they make allocations based on those pledges, right? That's exactly what UJA was doing.
Right. I think that, and coupled with the loan they received from the bank,
Right,
might just make it more of a tangible detriment than the UJA's case.
So again, I'm not going to try to, because we talked about this earlier, I don't want to dig too much further into this idea, but I do wonder, what is the difference between, like, what's the meaningful difference in detriment if you use your own money versus borrowing money to do something? In one case, right, you've incurred the obligation where you have to repay a bank. In the other case, you have lost the opportunity to use money that you already had. Right? Aren't those both detriments?
Yeah, I think they are both detriments. I think the one does refer to, there's an additional cost because they actually have to pay someone back, so they might, they don't have that money. They've gotten a loan from the bank, and so they have to pay them back eventually, and
Right.
they have to have that money. And maybe because someone else is involved in that, that's like an additional third party.
Okay, so I feel compelled. I said I wasn't going to do this, but I'm going to do it anyway. I feel compelled to talk about this a little bit more. So let's imagine that you have $10,000 in the bank, right? And you're planning to use that $10,000 to buy a used car, okay? And I tell you that I am going to give you $10,000, right? And so instead of using that $10,000 to get a used car, you use it to, make some necessary improvements around the home and do some other things that you've been putting off. And so you deplete that $10,000 that you no longer have, right? And then I don't give you the $10,000. Can you see that you have now lost the opportunity to do what you otherwise would have been able to do had I not made the promise?
Yes, that's true.
Because you used that money for something else, right? Because you expected my money to come, my money was going to help you, right? Do this other thing. And I guess that's the point I'm making, right? Is that I wonder, I guess I think, right, that seems to me to be as much a detriment as incurring an obligation that one would have to repay to someone else, right? It's, you have, you have this obligation to repay. That's unquestionably a valid detriment, I think. But I think I don't really see how it's meaningfully different than losing the opportunity to have that $10,000 in your account that you could spend on a car or save and get interest, or invest in a company or buy stock, or do there's all kinds of things you could do with that $10,000, but you've lost that opportunity. That to me is a tangible economic detriment. So I'll just leave it at that, and maybe ask you all to just think about it here a little bit. So let's, I think we've kind of dealt with this in the last opinion, but would you agree that a promise was made here?
Yes, I agree.
Okay, and does this court require reliance?
Yes, they were looking at sufficient consideration as well as reliance.
Okay, so they have actually two theories, right? So one is that they're looking to see if there is kind of traditional legal consideration. The other is, right, whether there is reliance on the promise, right? And so I guess I would ask then, and they also, by the way, do mention this third theory that they don't seem to, that Massachusetts doesn't seem to use, right, which is that maybe it should just be enforceable without proof of reliance for policy reasons. So what's the reliance here? I think we've pretty much talked through that. So let me ask you this question, and then I want to point out a couple of things. What do you think is the better policy? Do you think that it is a better policy to require reliance in the context of charitable subscriptions? Or do you think that it is a better policy to simply enforce charitable subscriptions without the need for reliance?
I think that having reliance is important, because it's important to show that the funds, the pledges that were made, were going to be, the charity did depend on them to do something with them. And although I think in some of the readings it did say that you don't have to, there doesn't have to be, you don't have to have proof that the charity did use the funds in a certain way.
Right.
So I'm not entirely sure.
So I want to make sure that we take a moment at least to pay attention to restatement section 90. So if you've got it handy, this is part of the reading for last time, but I just want to read a couple of things from the restatement that are useful, right? So we've been focused a lot on restatement 90 subsection 1, right, which gives us kind of our doctrine of promissory estoppel. But if you look at subsection 2, it says that a charitable subscription or a marriage settlement is binding under subsection 1 without proof that the promise induced action or forbearance, right? And so what the drafters of the restatement have said is that they think that a good rule is to simply allow enforcement of charitable promises, right? Charitable subscriptions or pledges without the need for determining whether or not there is reliance, right? And that's in fact what this court says, right? This court says the restatement of contracts, section 90, provides that a charitable subscription is enforceable without proof of reliance. And so what is what would the policy be that justifies enforcing a charitable pledge without proof of reliance, do you think?
I think maybe just that someone did decide to donate to a charity knowing that the charity was for the charity's purposes and the charity would use it for its purposes, and they don't need I guess if I were to look into it, if I were to donate to a charity, I won't be asking them for proof to show me that whatever I donated is used in a certain way. I just reasonably believe that they are a charity, they have been doing this work, that they will continue to do that, and whatever donation I make will be for that, and they don't really need to prove it back to me.
Okay, so there's an issue of proof, right? But the question I really have is this notion of reliance in the first case, right? So why is it that there's seems to be some policy consideration to say we're going to enforce this promise without proof that the charity actually relied on that to make any of its decisions? Like, why is that? Why might that be a good thing, right? What do charities like? Where do charities get their money?
From donations.
Right? Almost virtually all of their income is from donations, right? I mean, this is it's not entirely true in all cases, right? But right, there's many certainly many charities make, I mean, that the whole notion of charity, right, is to, right, that there are private funds being donated and given that are then used for the public good, right? So this policy would encourage enforcement of those promises, which would inure to the benefit of the public, right? It would also, if we kind of think about the fact that charities depend on these pledges to survive, we might, instead of saying depend on, we might say they rely, right, on these pledges to survive. And so as a result, then maybe kind of the notion of reliance, even if it lacks some degree of specificity, is kind of inherent, right, in the charitable pledge, right? So anyway, notwithstanding that, right, some courts follow subsection 2 of restatement, section 90. Others do not. Thank you. I want to make just one observation before we take a break. I want to note, and this is, let's see, maybe the fifth. Yes, technically the sixth paragraph of the opinion. It begins, the allowability of claims. I just want to make sure you see that paragraph. So do you see that? The allowability of claims is to be determined under state law. Everybody sees that? I want to just observe that this is reflecting something that we have talked about. So this is a United States bankruptcy court, a federal court that is applying state law to determine whether a promise is enforceable. Can you see that? Right? So this is not a state court in Massachusetts. This is a federal court in Massachusetts that is using Massachusetts law to determine whether or not this promise is enforceable. And this is just kind of goes back to when we were talking about the structure and relationships among courts, that federal courts in some circumstances when they're dealing with state issues will apply state law. This would be an interesting case in bankruptcy court where they're unquestionably applying federal bankruptcy law, right? But to determine the validity of a particular claim, they actually have to apply state law on promissory estoppel. Okay? All right, so let's move on to King versus Trustees of Boston University, Supreme Court, Judicial Court of Massachusetts. Let's see. perhaps we can go to Mr. Link. Have I called on you before? Have I already kind of put you on the hot seat?
Not yet.
Okay, well, here we go then. And I've definitely lost track. I feel like I got an email from someone saying, "Hey, I haven't been on the hot seat yet." I don't remember now who that was, but but I'm happy to try to catch you later too, because we still have 2 more cases to go. So again, my goal is to get you. Thank you for letting me know. All right, so I will. Let's talk about King versus Trustees of Boston University. Let's maybe you can tell me who the parties are and how did we get here.
Sure. So the parties are Coretta Scott King, who is the appellant, and she was the plaintiff at the lower court. And then we have the trustees of Boston University as the appellee, and they were the defendants in the lower court. Coretta Scott King sued Boston University, alleging that the estate of Dr. King, not the university, held title to Dr. King's papers. The case was submitted to the jury on theories of contract, charitable pledges, statute of limitations, and laches. And the jury determined that Dr. King made a promise to give absolute title to his papers to the university in a July 1964 letter, and that the promise to give the papers was enforceable as a charitable pledge supported by consideration or reliance. That means they also found that the letter was not a contract. The trial judge also denied Coretta Scott King's motion for judgment, notwithstanding the verdict, or for a new trial. So she appealed to this court.
Excellent. So thank you. So we see again, right, this motion for judgment notwithstanding the verdict, right? So the case went to a jury, right? And there's this post-trial motion for the entry of judgment notwithstanding the verdict. In other words, this is another situation where the moving party is saying this case is so one-sided, I should have won and never should have gone to the jury in the first place, that no reasonable jury could have concluded what this jury has, and therefore, judge, I'm asking you as a matter of law to enter judgment for me instead. Okay. Just really quickly, it says that this was submitted to the jury on theories of contract, charitable pledge, statute of limitations, and laches. So I feel like that language is slightly confusing because it makes it sound as though maybe there are 4 claims here. So how would you characterize the statute of limitations and laches kind of theories? Are those claims?
The way I understood it, they were somehow tied to the contract claim. So I guess if a contract was established, then they may have come into play, and the charitable pledge probably wouldn't have been a thing. But since it was ruled that it wasn't a contract, those also died.
Okay, so what do you have in mind generally what statute of limitations means?
Just the time in which you are legally allowed to bring something to court.
Right, so if there is a breach of contract, right, that you have a certain amount of time within which, or if there's any kind of claim, right, you have a certain amount of time within which you can bring that to court, right? So I think we're actually told that among other things that that this is a suit for conversion, right? That's really the plaintiff's claim here, as it said, it's a suit for conversion, which I believe we talked about recently, right? The idea that conversion is taking the property that belongs to someone else, right, and making it your own, right? So I actually think as we look at these theories, as the court says, of contract, charitable pledge, statute of limitations, and laches, that these are all actually defenses to that conversion claim, right? It's the Boston University claiming that we had a contract, or we're entitled to enforcement of a promise as a result of a charitable pledge, or the statute of limitations has run, or this thing called latches. So what is latches? Is that something you figured out as you were going through this? Or, I mean, it says here that they didn't reach a decision on it. The court doesn't address it. So it's totally reasonable, I should say, for you to have not looked it up.
I did briefly look it up
Okay.
to get the definition. And I have a note that says unreasonable delay in making a request.
There you go. That's all we need, actually, right? So latches is what we call an equitable defense, right? So I'm not going to get into kind of a deep discussion here about courts of law and equity, but at common law, there were courts of equity that dealt with certain kinds of claims, courts of law that dealt with other kinds of claims. And among the defenses that you could present in a court of equity was the defense of latches. In other words, that it would not be equitable to give the plaintiff what she asks because she has waited too long to ask for it, right? It's not really going to the merits of the underlying claim, but really saying that that by waiting so long, basically you've forfeited that claim, right? Or you can't be sincere in your request if you waited this long to ask for it. So it's just useful to kind of know what that means. You'll come across latches again. There are other equitable defenses, like the defense of unclean hands, which says that even if I am a wrongdoer, so is the plaintiff, and so there are other things like that. All right, so the jury finds that the letter promising the papers was not a contract, but it was an enforceable and charitable pledge. So what's the legal question that the court is trying to answer here in this case?
Was there sufficient evidence at trial to submit the question of charitable pledge to the jury?
That's exactly right. And I want to really thank you for kind of articulating it that way, right? So it's really easy for us to look at this and say that the court's legal issue is to determine, right, whether or not this was a legally enforceable charitable pledge, right? And it does a lot of analysis kind of on that point. But really what the court is focused on here, and this is really useful as we think kind of about narrowness of holdings, right? The court isn't really superimposing its judgment, right? Saying that, yes, the jury made the right decision. All it is saying right here is that either there was or there wasn't sufficient evidence to have submitted this to the jury and let them decide. So in other words, this case was sufficiently in dispute to allow this case to go to the jury. Does that make sense to everybody?
I have a question.
Yes, please.
I guess I was a little confused that I didn't understand what the procedure would have been had it not gone to the jury. Like, would the judge have just decided, or?
So this is why we see in the procedural history, for example, a motion for judgment notwithstanding the verdict, which we used to call JNOV for some reason. I think we may have kind of moved on from those letters, but you may see JNOV in some opinions. So if you ever see it, you can know that it means judgment notwithstanding the verdict. I think it actually means judgment non-obstante verdict or something like that. But it just means, what it really means is that, okay, the case was submitted to a jury, but it never should have been, right? There isn't evidence to support the jury's conclusion. This case, again, in the simple terms, this case is so one-sided that it should have been just decided as a matter of law. So I feel the compulsion, by the way, to spend a little more quality time with you on talking through procedure, because I've kind of done it piecemeal. So I may set aside some time, I think, next week to do that more effectively. But it's just useful to kind of have in mind that there are a range of motions that might be presented during the proceeding. Some are before trial occurs, some occur like during the trial, some occur at the close of evidence, but before a case might be submitted to the jury, and then some motions like the one we're looking at are brought after the jury has returned its verdict. And each of these motions, it presents an opportunity to preserve an issue for appeal, right, and to identify a moment in the proceeding below where the trial court made an error, right? You can't appeal just because you don't like something, right? You have to actually say that the trial court made a mistake in some way, right? And you must have preserved that mistake. And so by making this motion for judgment notwithstanding the verdict, the plaintiff is saying, well, this is an error, judge. Like, I don't expect when I do this, you're going to rule in my favor. I don't expect you're going to superimpose your judgment over the jury. You let it go to the jury in the first place, right? So, but what I am going to do is file this motion so that when you deny it, I have something to appeal. Does that make sense? And is that responsive to your question? Because I just like went off on a whole rant about this, but
Yeah, I think so.
I think so too. But if not, please feel free to come back to me and let me know if there's more clarification I need to give. So the court is determining whether or not there's sufficient evidence of that to have gone to the jury on the question of whether or not this is an enforceable charitable pledge. So so what is what rule or rules does the court use to determine the answer to that question?
Sure. So they looked into two questions. One, whether the evidence was sufficient to sustain a conclusion that the letter contained a promise to make a gift.
Okay.
And then second, whether the evidence was sufficient to support a determination that any promise found was supported by consideration or reliance.
Okay. And so on the first question, is there evidence? What did the court determine was or wasn't sufficient to at least send to the jury on the question of whether a promise was made?
So they established that a promise was made, and they focused in on part of the letter, which read, I intend each year to indicate a portion of the material deposited with Boston University to become the absolute property of the university as an outright gift from me until all shall have been thus given to Boston University. And through that statement, they said that the university and Dr. King established a Baylor-Bailey relationship,
Okay.
Which required which essentially was similar to Dr. King giving the papers over as a gift in exchange for their security and safekeeping.
Okay, so thank you. So let's talk about a few of these different things, right? So just because you mentioned it last, let's talk really quickly about what is a bailment? What is a bailee or bailor? What does that mean?
I understand it as when you give something to someone in order for them to take care of, and then once you want it back, you can get that back. So I guess maybe like a valet key, or like if you give your keys to a valet, they become the bailor. No, bailee.
It would be a bailee. You're right. Okay.
And then once you want your car back, they give you back your keys, and the relationship is relinquished.
Yes. So the basic idea, right, is that you are giving custody of something that you own, right, to someone else, right, and that they are kind of bound by that relationship to care for it in a particular way, right, because you've entrusted it to them, and then at some point you get it back. Just as an aside, every time that you have ever given your keys to a valet, you got a little ticket, right? That you could use to get your car back. And have you ever read the back of that ticket? Anybody? No, nobody's ever read the back of that ticket. Well, I'll tell you what, the next time you get it, read the back of it. It's among the things that it will say, and maybe even the first thing that it will say was that this does not constitute a bailment, right? And part of the reason that they do that is that they don't want to be held to a higher standard of care for your car, where they would have to protect it from injury, for example, if someone else were to bump into it, right, and scratch it or whatever. Like that's not, they're not planning to do that. So every parking garage where you've gotten a ticket, every place where you've given your car to valet, I guarantee you the back of that ticket that you got says that this does not constitute a bailment for that very reason. Otherwise, it would look exactly like a bailment. And I think your valet example is a perfect one, except that you can contract out of it, right? You can. It has to be the relationship has to be one that is actually agreed to by the parties. So um, so here, I guess, is my question: if the nature of a bailment is such that I am giving something that I own, that belongs to me, and to which I have the right to recoup. If that's what a bailment is, and the court here, I think, says that this indeed was a bailment. Am I right so far?
Yeah.
How does that jibe with the fact that, with the argument that that Dr. King was in fact giving these papers to Boston University?
Well, I think in the sentence, I don't know if it's in that exact sentence. At some point in the letter, he talks about how periodically papers will be given into their possession.
Right. So there's this whole argument in this case about kind of the nature of a kind of a statement of intention versus a promise, right? We've seen that argument a couple of places. And let me read the sentence for you. I intend each year to indicate a portion of the materials deposited with Boston University to become the absolute property of Boston University as an outright gift from me. So it begins with the words, I intend to do this. And that is at least part of what this court is relying on, right, to determine that there was indeed a promise made, right? Am I right about that?
Yeah.
And so if this was indeed a promise, do you think that between 1964, when these papers were given over to Boston University, and 1968, when Dr. King was assassinated, that he could have said, give them all back to me. I'm not going to give you a title to anything.
I would say that he could say that for those that he hadn't given completely over. For the ones that he already handed over, I feel like.
So, I mean, if we read this letter, right, it says that, in fact, let me just read some more of it, right? It says that let's see, I'm losing, I realized what's happened. I kept thinking I was going to the previous page, and I was actually going to the next page because my thing isn't stapled. Sorry. So it says in the previous paragraph, from the one I was reading, all papers and other objects which thus pass into the custody of Boston University remain my legal property until otherwise indicated. Right? Mm-hmm. So I guess let's imagine a situation where Dr. King at no point actually indicated any portion of the materials deposited with Boston University, right, to become their absolute property. Wouldn't that have then, under the terms of this letter, remained his legal property?
Yes, but I think that the important piece too is where he mentions should he pass away,
Mm-hmm.
all materials go to the university in that last sentence there.
And
Um,
and so I guess this raises the question, right? If he retained the option to do nothing, right? So I do want to focus for just a second on what he could have done while he was alive. And I think, but I'm not sure. Do you agree with me now that while he was alive, to the extent that he had not indicated some portion of those materials to become the absolute property of Boston University, that he could indeed say, give them all back to me? Do you now
Yeah.
agree with me on that?
yeah.
Okay, so if he retained the option to do nothing, then how is that promise that in the event of my death, all of these materials shall become the absolute property of Boston University? How is that a meaningful promise if the set of documents referred to there could possibly be zero?
I guess I would argue that while those documents were in the care of Boston University, they still expended energy, time, money to take care of them.
But wasn't that their obligation under the bailment, right? On the bailment, right? The court says here that they assumed the duty of care of, as bailee set forth in the letter, that of, quote, scrupulous care, right? So that expense that they incurred as a result of this bail or bailee agreement, this bailment, was that the things that we see them do is really consistent with that, right?
Right.
Like, do you think, again, and I'm not trying to push you, I'm really just trying to see, like, how far does this go for you? Like, again, while Dr. King is still alive, do you think Boston University would have an argument, no, you can't take them back because we've expended this energy, this money on kind of caring for these things?
Probably not.
Why not?
Just because, as you said, it was part of their Bailey-Baylor agreement. So I guess they were just abiding by the terms of that.
Okay, and so if that's the case, then how does the legal how does the legal situation change upon his death? I mean, why is the status of those papers different? If he could have taken everything back beforehand, isn't his promise to hand them over an illusory promise? So we talked briefly the other day about illusory promises. Let me give you an example of an illusory promise. An illusory promise says something like this: I will give you $150,000 if I feel like it. Right? I'm not obligating myself to do anything then, am I?
No, because you could choose, you could feel not like giving me anything.
That's exactly right. Is this promise, if it is a promise, different?
I don't think so. I feel like the kicker is when he specifies his death. So
And that's specifically what I'm asking about. Like, so why does that make it different?
I think
And it very well may.
Yeah, I think it makes his promise more specific. Like it gives a time frame. So I guess if I had to use your example of you'll give me $150,000 if you feel like it, there's no time frame on that. But if you say, or I don't know if this is making any sense.
You're doing great. Keep going.
I guess if you were to say, if you feel like it, or in the event of my death, then should you die, you fulfill that term of the promise and it becomes mine.
So I want to just think about that particular occurrence and why it might be meaningful. Again, if you have the restatement sections in front of you, I would look at section 2 for a moment. And which is defining a promise. And let's go to the comments. I want you to look at kind of comment E. We don't have to read through the whole thing, but comment E really focuses on illusory promises and mere statements of intention, and it gives some guidance, right, as to how we might understand the distinction between an illusory promise and what we might call a conditional promise, right? And so here we see, actually, if you look at the illustration 3, in comment E, it says, A says to B, I will employ you for a year at a salary of $5,000 if I go into business. And then it says to us, this is a promise, even though it is wholly optional with A to go into business or not, right? So part of what this is indicating to us is that promises, the kind of trigger for the enforcement of a promise, sometimes there has to be a condition met, right? And so sometimes that condition, whether or not that condition is met, could be optional, as in the case of, right, the in the case of this person saying, I'll hire you if I go into business, right? It's that promisor's within that promisor's sole discretion to decide whether or not to go into business. But if that condition occurs, then the promise becomes enforceable. So I think what really we have to understand is that there is a difference between saying, I'll pay you $150,000 if I want to, and saying, I'll give you $150,000 if, whatever, if you, make first squad for the Mets. I don't know. I couldn't think of anything good, so that's what I went with. I don't even like the Mets. So maybe this looks a little bit more like a conditional promise rather than an illusory promise. But you can kind of see then how these arguments are kind of shaping around this notion of kind of future intent, intent to do something in the future. And I think you've really already said it, so I want to at least just observe kind of the notion of what the reliance was here, was of kind of curating this collection, right, and kind of doing the things that any institution would do if it had the papers of a legendary figure like Dr. King, who, by the way, I don't know if I don't recall now if it says this in the opinion or if this is just something that I know, but that's where he got his PhD, right? We call him Dr. King because because he got a PhD at Boston University. And so there was there's some reason why, right? He actually did give them to BU. The last thing I guess I would observe here. This is not a particularly meaningful thing, but there's something just wonderful about reading cases written by really smart people. And I remember the first time that I taught this case, which is where I learned the word eleemosynary. And I hope you can just hold on to that for the rest of your lives too, because eleemosynary is an awesome word, and we should all use it more often. All right, so we have 2 more cases left. Let's try to knock these out, and then we'll take another break. So let's start with Aceves versus U.S. Bank N.A. And let's go to Matt Dumont. Matt, how are you doing?
I am so ready to crash and burn.
Awesome. It's really good to have a good attitude leading into the cold call. So yeah, it's nice. You have an awesome growth mindset. So all right, let's jump in. Who's Aceves? Who's U.S. Bank? And what's going on here?
Yep. So I have that the plaintiff is Claudia Aceves, who is also the appellant. I have the defendant is U.S. Bank, who is the appellee. Do you want me to go into the procedural?
By all means.
The original complaint was filed on April 1st, 2009, and then there was an amended complaint filed 2 months later after a demurrer, which I looked up to mean objection, was sustained by the defendant. A second amended complaint was filed. At the demurrer hearing, the plaintiff's attorney argued that the defendant said that they'd work with her, and the plaintiff relied on that promise. The trial court disagreed. Foreclosure proceedings took place because in the trial court's opinion, there was no fraud or anything that deluded the plaintiff. The trial court sustained the demurrer without leave to amend and ruled in favor of the ruled in favor of the plaintiff. Ruled in favor of the defendant. The plaintiff appealed to the California Court of Appeals.
All right, so let's first explore this idea. You've looked up the term demurrer.
Yeah.
What is, you said it's an objection. What is that? Can you give us a little more insight?
I'm not sure that I have more insight than that.
All right. So again, this is another one of these procedural moments, right? In a matter that tends to occur at the very beginning of a case, right? So a plaintiff files a complaint. One of the options that a defendant has after the complaint is served is, of course, to file an answer. We've seen that, right? A complaint and then an answer. Something else, though, that a defendant could do instead of answering would be to file something that might be called a demurrer, right? It might be called a motion to dismiss for failure to state a claim upon which relief can be granted, right? And so what this does is says to the trial court, this is not exactly like we've talked about with summary judgment motions or judgment notwithstanding the verdict. This is not a claim it's not a motion that says this case is so one-sided that I should win, right? Because those motions contemplate the evidence.
Mm-hmm.
Does that make sense?
Is it more that there's no case at all?
So it is that, but it's really based on the language within the complaint, right? So it's not looking at evidence at all. That's really the big distinction I want to make, right? The motion for judgment notwithstanding the verdict contemplates the quality of the evidence and is seeking to conclude that the evidence is so one-sided that the case must have been decided in only one way. No reasonable jury could decide otherwise. A motion for summary judgment says before the trial that this case is so one-sided based on the evidence that I must win, so just enter a judgment for me now. There's no reason for it to go to a jury, right? And there are other motions like that. A demurrer, or a motion to dismiss, on the other hand, says that let's take everything that the plaintiff said as true. Let's accept their allegations for the purpose of this motion. And even if we accept their allegations, they still can't win. Does that make sense?
Mm-hmm.
Right? So it's not talking about the evidence at all. It's simply looking at what did you allege in your complaint, and let's just take it as true. Like, you get the benefit of the doubt on everything that you've said there, right? And even so, you can't win the case, right? And it's asking the judge to dismiss. Now, what will happen sometimes is that a party will file a complaint, the defendant will file a motion to dismiss, and that motion to dismiss might be granted, but without prejudice, meaning that that it's not saying you can't come back, right? It's just saying, like, you have a flaw in your pleading, and often we'll see then an amended complaint. We don't have clarity here on whether the amended complaint, I don't think, kind of followed an initial. We do have clarity on it, right? So there's
several.
There's a first amended complaint, there's a demurrer, then there's a second amended complaint, right? Mm-hmm. And so you can kind of see like that how that process plays out. It's a way at the beginning to kind of refine the pleading so that we can see, is there a case to go forward at all?
Do you mind if I ask a question?
I do not mind at all.
So I had a little bit of trouble with the procedural history here,
okay.
Because of this demurrer hearing. Am I pronouncing that right?
Demurrer, yes, demurrer.
Okay. It mentioned that there was a demurrer, and then that was sustained, and then a second amended complaint is filed, and then it mentions a demurrer hearing. Is that referring to back to that first demurrer, or is this an additional demurrer? As in, did they file a second against the additionally amended complaint?
So
I was just kind of confused about that procedural history.
Sure. So what I would do really is just kind of look at the dates. We'll answer the question for you, I think, right? But effectively, what's happening here is that there's initial complaint, first amended, demurrer, second amended, demurrer, right? And then we're at the trial court, and the trial court sustains that demurrer on the second amended complaint, and then now Aceves, right? Aceves is like, okay, there's nothing else I can do now, right? Except just appeal that, because this court is clearly not going to let this claim go forward in the end. So there's an appeal on what is a demurrer to the second amended complaint.
So just as for clarity on my sake,
Sure.
because it says complaint, so it says a second amended complaint, and then it says complaint in parentheses again was filed. Does that indicate that there was that second demurrer? Because I don't see, I'm just not finding that clarity.
Yes, I understand. So here's how I would understand it as somebody who has read this stuff more, right? So once you start out with a complaint. When the first amended complaint is filed, it supersedes the prior pleading. So that prior pleading is kind of meaningless at that point. All right. There's a demurrer that is sustained on the first amended complaint, right? Which means it's no good. Right. So now we have a second amended complaint. So when the court here is calling this in parentheses complaint, right? They're basically saying from now on, when we say complaint, we're referring to the second amended complaint. So they're kind of defining it as a term of art here. And so when we get to the part 1B of the opinion, and it refers to a demurrer, right? It's really is referring to the
second amended
demurrer to the second amended complaint.
Gotcha.
It also, the other reason why that makes sense, right, is that there would be nothing to appeal from if on the first demurrer, because Aceves filed the second amended complaint. That's the relief, right? Is to file that second amended complaint. And so now this demurrer would be to the second amended complaint, and we can see that the court grants or sustains the demurrer, and here it says sustains without leave to amend. Do you see that?
Yes.
Okay.
Yep.
So what does that mean? Sustained without leave to amend and a judgment in favor of U.S. Bank. So what that means is the court says you've had 3 bites at the apple and you have not yet given me a sufficient complaint. I don't believe you can, and as a result, I'm not going to give you another chance to file a complaint here. You do not have leave to amend, and not only that, but I'm going to enter judgment on behalf of the defendant here.
Makes sense. Thank you.
Sure, no problem. All right, so I feel like I was a student there for a second, but all right. So tell us kind of, if you can, what are the kind of main legal issues here? I think you've given us kind of the basic factual background already, but what are the big legal issues here?
So my issue from the case was, can a promise to merely negotiate be enforced through promissory estoppel in a mortgage foreclosure proceeding?
Okay, and so and it might be useful to think about, right, if we're kind of going to end up being really precise, right, that the the real legal question might be whether the trial court erred, right, in granting or sustaining the defendant's demurrer to the second amended complaint. In other words, did the second amended complaint validly state a claim upon which relief can be granted?
Gotcha.
Does that make sense?
Mm-hmm.
Okay. So, the thing I love about this case is that from here on out, right, the court's really great with its organization and discussion. So it helps us answer these questions in a really great way. What rule does the court apply to answer this question?
Sorry, let me scroll down.
It's okay.
Yep. So, so I have I go back to the promissory estoppel claims in that there was a promise that was clear and unambiguous. They promised to negotiate with her in multiples of ways. There was reliance there was foreseeable reliance by the plaintiff in that she expected to be able to negotiate. There was actual reliance that was foreseeable in that instead of instead of filing for the different level of bankruptcy, the Chapter 13 instead of the Chapter 7, she anticipated being able to negotiate to stay in her home for potentially mutually beneficial outcomes between her staying in her home and getting a decent mortgage rate, and also the bank, of course, getting the outcome of getting their money. And then there is definite injustice in this aspect because they did, in fact, foreclose, auction her home, evict her, and the like. And so I felt like it was a pretty straightforward promissory estoppel case.
Okay, so I tend to agree with you. I want to dig a little bit deeper on the rules just a bit. So
Sure.
First I want to observe, right, the court's definition of promissory estoppel, right? It tells us here the elements of promissory estoppel are, and it gives us these 4 elements. These 4 elements, I think, match pretty closely to the things we've talked about. I would note that the court's 3rd element says that the reliance must be both reasonable and foreseeable, right? So as we've been talking about it, maybe in 5 elements, it's just they're kind of combining foreseeability and the reasonableness, right, of the reliance. But otherwise, I think it matches pretty closely what we've been looking at so far. We see certainly kind of the court's discussion of a promise. I guess the question I might have is there a promise that U.S. Bank made not to foreclose on Aceves' property?
No, they only made the promise to negotiate with her, which they didn't fulfill because as the facts of the case progress, if we take them at Aceves' word, which we're supposed to in this instance, since they demurred, if I'm understanding that right, we're taking her word as fact. They essentially did not negotiate because they said this is the offer, take it or leave it, and that's not a negotiation. And so there was the promise to negotiate, and they did fail at that promise. It did not say that they would not foreclose.
Okay. All right. And so I think it's easy to see, right, and the court even only spends 4 lines talking about it, that Aceves did in fact rely on the promise, right?
Yes.
So, and the specific reliance here we see is choosing not to convert from Chapter 7 to Chapter 13.
Right.
In bankruptcy. So was the reliance reasonable?
I argue that it is, because in the idea of negotiating with the bank, it is likely to be assumed, and I think they make this point, that she would get a better outcome that is mutually beneficial not only to her but also the bank. In the idea that maybe her rates, I think they make a couple of posits that her rates might be lower, for instance. The
Right.
term might be extended, and all of those things are far superior outcomes to her. One, in that she also gets to stay in her home, but that the bankruptcy procedures was a far shorter term. It was something like 5 years as
Right.
opposed to 30.
Yes. So I want to observe that when we are thinking about whether reliance is reasonable, that this court actually gives us a rule. I don't think we've seen a rule on that yet. So there's some language here that I think is useful to pay attention to. Now, it may not be kind of the be-all, end-all rule for reasonableness, but at least we have some guidance, some language we can kind of draw on to determine whether something is reasonable. In the second paragraph,
The party's plaintiff.
yes, right. That begins a party plaintiff's misguided belief or guileless action, etc. Right, isn't justifiable reliance. So at least we have some guidance, at least to what a court would say is not reasonable, right? And so I think that would be an important thing for you all to note as you were thinking about doing analysis, right? So if you recall, even in our last class, we were talking. We were working on analysis for whether a promise had been made. You'd have to do, in a promissory estoppel discussion, you'd also have to do a separate analysis of whether or not reliance was reasonable, right? And so this gives you some rule to kind of bring into that analysis. And I would note, by the way, here that the court also kind of focuses on a detriment, right? So we've focused a lot on the way restatement section 90 kind of articulates it, that justice requires enforcement, right? Here, the Aceves court says the party asserting the estoppel must be injured by the reliance, right? So it's really looking at injury, and so there may be some degree to which we might equate that with justice requiring enforcement, right? Not just reliance, but reliance to one's detriment, right? That there is injury or harm that comes as a result of the reliance. Let's see. Are there other things that you think are important for us to take away from this case? I know you said you felt like it was pretty straightforward.
I mean, I think it is straightforward, but I thought that one of the distinctions here was a promise to do something that is like, that's sort of intangible. Like a lot of these cases that we've dealt with previously was, okay, I'm going to give you a promise to this land or this piece of property or money or those kind of things. And those are all sort of tangible assets.
Right.
It felt interesting that the distinction here was a promise for action that did not necessarily also promise a result. Like they did not promise to come to a good faith negotiation that has like this particular outcome of her
Right.
staying in her house.
Right.
I thought it was a really interesting distinction that it was just to negotiate in the first place.
Right. So I think that that's a good question, but I think that the question really should be, when we're thinking about promissory estoppel, right, is what was the extent, what was the reliance, right? What was the detriment in reliance on whatever the promise was, right? So here, there's a pretty major thing, right, that they say, if you move forward with your motion to change this from a Chapter 7 to a Chapter 13, we will not be able to negotiate with you. Like, we're not going to be able to work this out. If you withdraw your motion, then we will be able to negotiate. We'll negotiate with you to try to work this out and avoid foreclosure. So when Aceves sacrifices, right, the option of moving from Chapter 7 to Chapter 13, there's a lot of protection lost there, right? There's 5 years of time to kind of get right on the loans and kind of figure it all out, right? And so there's a significant lost opportunity there, right, as a result. And I think that's really what the court is focused on, right? It's not that the harm here isn't that Aceves lost the home in a situation where Aceves would not have had she not relied on the promise, but the question is whether she sacrificed important legal rights, right, as a result, right? She had every right to convert this to Chapter 13, right, as the court says, I think somewhere in its opinion, right, that one of the main benefits of Chapter 13 is being able to stay in your home, right? Yeah. That's one of the main benefits, is to protect the debtor against foreclosure, and of course, the very thing that this promise was designed to do, right, it was to get her to withdraw her motion to convert this to a Chapter 13, is what she did. So it's clearly foreseeable, right? It was not only foreseeable, it's actually the reliance that they intended, right, to occur, right? And what do they do immediately? They stop negotiating and foreclose, right? So yeah, I think the court here isn't focusing on, kind of saying that, she would have kept the home and all would, she would have been able to negotiate a perfect, resolution with the bank had they agreed. But the fact that they didn't, they made this promise and then didn't keep the promise, in reliance on that promise, she suffered a pretty significant detriment. Is that responsive to your question or comment?
Yeah, no, absolutely. I mean,
Okay.
I totally, yep.
Okay, great. So I want to just add a little bit of context for this case also. It's easy sometimes to read cases and focus on the law, and you can do that here. This is a great promissory estoppel case, well written, and it gives us a lot of really good information on what is a promise, what does it mean for reliance to be reasonable. So it gives us some really good structure on how to kind of analyze a promissory estoppel claim. But I do want to just provide for just a moment a little bit of context, kind of an overlooked aspect. If we just look at the promissory estoppel claim, there's some stuff overlooked here, right? So when is this case decided? It's decided 2011, I think. Does that sound right to you?
Yeah, it was recent.
Yeah.
I think it was 2009, but it was pretty
So I think
like last decade or so.
Yeah. So the opinion is 2011. If we look at the facts, we can see that Cebes bought the home. Let's see, in 2006. Is that right? Or got a loan?
She got a mortgage based on the equity in 2006 and then defaulted in 2008.
Yes. And so I want to observe kind of how this fits in historical context, right? So many of you are like in your early 20s. And so what that means then is that in 2006, you might have been like, I don't know, 6 or 8 years old or something like that. I don't know. That's about right, isn't it? And so you may not have like a great frame of reference, but I imagine at least you are many of you may be somewhat familiar with the fact that there was a pretty significant housing market crash in 2008. Are you aware of that? Kind of familiar with this as a historical thing?
I'm in my late 30s, so okay. I remember.
Very good. Very good. All right. So, it's important to really kind of have in mind in the context of this case what has happened, what is happening in 2006 when Aceves kind of enters into this adjustable rate mortgage that's with an initial rate which is really high of 6.3%. 6.35%, right, and is bound to go up, right? Mm-hmm. And so, what is happening in the early 2000s, leading up to 2006, is that there's this huge push nationally for people to buy homes, right? Banks are lending money to everybody, right? You can go to a bank. You don't have to prove income, right? You can do what they call no document loans, right? Where you don't have to actually prove your income, right? You can just show up, right? And fill out some forms and the bank will give you a loan, right? Because it's housing. Housing always goes up, right? And there's this huge bubble that is growing in the market, in this housing market. So part of the reason, and I should also add that there are a couple of other things to have in mind, right? That just historically, people of color, in particular, historically, right, have been marginalized when it comes to home ownership, right? That there is something called redlining. I don't know how familiar you are with that, right?
Predatory loans.
Well, so yeah. So on the one hand, redlining, right, which banks use to decide whether they wanted to give loans or not, right? In the redlined areas, right, they would say, well, that's where the people of color are, and we're not going to lend to them, right? And so this had a real impact on ownership in the early 2000s, there's a shift to what Matt correctly is identifying as predatory lending, right? Where these loans with ridiculous terms, right? These adjustable rate terms. So you kind of start out with kind of what is initially perhaps a manageable mortgage, right? And there's this promise, because housing always goes up, that you'll just be able to, in a few years, you'll be able to renegotiate that loan anyway. You'll be able to refinance, and you can do another one of these loans, and keep your mortgage low. And so there was this predatory lending that took place, and it was focused a lot on people of color and people who had been excluded from the housing market. And so this bubble is kind of built on the backs of those people. And the banks are suddenly willing to take these risks, right? And especially on these no-doc loans, in places where there isn't really evidence that those who are borrowing will be able to repay under the terms of these loans. The reason the banks are willing to do that is because these loans are then, and I'm not an economist, so I'm going to give you kind of my layperson kind of understanding, but you should watch The Big Short. Like, if you've never seen that film, like, that's a good film to kind of explain how this works, right? But so what happens is the banks like take all these loans and they kind of package them together, right? And then they sell them off. So the bank kind of makes its kind of income, and investors are now, right, all these market investors are investing kind of in these funds that are secured by these mortgages, right? They're depending on the repayment of these loans, right? And because these things are kind of grouped together kind of in bulk, right, that they get like these higher investment ratings, and so people are willing to kind of invest more money, and the whole market is just like built on investing in these what they call like tranches of kind of mortgage funds. And what happens is, because the terms of these loans were so bad, because there was no kind of real effort put on the part of the banks to ensure that people had the capacity to repay, people began to default in massive numbers on these loans. The amounts weren't repaid. Houses, many houses went into foreclosure. Like, I don't know how many of you have ever been in the housing market, but there's like this term short sale that I don't even know if it was a term like 20 years ago, but like it's a really common term now. And what it is like, you're trying to buy a house that's subject to foreclosure, so you want to try to get it at a good price because it's a thing now, right? It's a thing that really kind of exploded after the 2008 crash. So I think that it's just useful. There are a couple of cases like this in contracts, and there are some in other areas where I think that it's really useful sometimes just to pay a little bit of attention to the subtext that's kind of, or the context at least, that's happening kind of behind the scenes with respect to some of these cases. And I think that at least is an important one. All right, let's try to quickly go through Shoemaker versus Commonwealth Bank. Thank you very much, Mr. Dumont, for your time there. Let's see, Shoemaker, let's go. Let me see, I'm going to flip my page here and see who else is on the other screen. It's like a lot of the same people. So how about Caitlin? I feel like I called on you like just last class, Caitlin. Is that fair? Did I call on you in the last class?
Which Caitlin?
Sorry, I did it again, right? Because I did that before also. So I definitely called on Caitlin. I feel like I called on Caitlin Gugliotta last time. Is that right?
Well, you called on me yesterday when we were talking about like the logic stuff. The other
that doesn't count.
Yeah, Caitlin Barnes answered last time that we were doing like cases.
Okay, so then we'll go with Caitlin Gugliotta then, right? That sound good? Caitlin Barnes is like, yeah, that's awesome. All right, so
last time as well. So
what's that?
That's how I reacted last time as well. So
excellent. All right, so Caitlin with a C, tell us about Shoemaker and Commonwealth Bank, please.
So I believe Shoemaker is the plaintiff and Commonwealth Bank would be the defendant. And what I have for the procedural history is that So Shoemaker sued Commonwealth Bank, alleging causes of action in fraud, promissory estoppel, and breach of contract. And then Commonwealth Bank filed the motion for summary judgment, which was granted. And then that judgment went in favor of Commonwealth Bank for fulfilling the promise to obtain insurance, even though they had let it lapse. There was no misrepresentation and no breached promise.
Okay.
So then Shoemaker appealed, arguing that the trial court erred by entering summary judgment on fraud and promissory estoppel.
Excellent. So what's the legal issue here?
The issue is that to determine whether a mortgager who is obliged by a mortgage to maintain insurance on the mortgage property can establish a cause of action in promissory estoppel based on an oral promise made by the mortgagee to obtain insurance.
All right. So, thank you. So was there a promise here?
I would say that there was a promise, yes.
Okay. What was the promise?
After the insurance lapse that the Shoemakers had, there was a promise to obtain insurance by the Commonwealth, but then they had sent another letter saying that the insurance was going to lapse again at the end, and I believe it was in December 1994, they let the insurance lapse, and then it had gone back to the Shoemakers, and it was their obligation to insure the home, which they failed to do, and then burned down.
So does this court, this is kind of an unfair question, so listen closely, all right? Does this court conclude that Commonwealth Bank made a promise to the Shoemakers?
Yes, I think that they did conclude that they made a promise, but they also conclude that they had fulfilled that promise.
Is the issue of a promise in dispute?
Since you're asking me, I want to say yes.
Okay. So, I've had this is like the fourth time this has happened today where I just ask a question and then there's just total suspicion about me when I ask the question. So let's focus for a second then on this motion for summary judgment, right? Because I think that you said that the error that's claimed here, right? This appeal is claiming error in the granting of a motion for summary judgment, right?
Yes.
So a motion for summary judgment, I think we see in this, or perhaps in an earlier opinion, a motion for summary judgment says that there is no material fact in dispute and that the moving party is entitled to judgment as a matter of law. Is the question of whether or not there is a promise a material fact?
Yes.
And is that in dispute?
Yes, because the Shoemakers allege that they did not receive the letter that stated that the Commonwealth is going to stop insuring the home.
Excellent, right? And so as a result, then, do you think that the court here is saying, yes, there was a promise?
I think, the court says that they shouldn't have held that. Since the question of a promise is in question, then they shouldn't have granted summary judgment in the first place.
Exactly right, right? So this court actually isn't reaching a conclusion on that. It's simply saying that question could have gone to a jury, right? That summary judgment wasn't appropriate here. In other words, this case is not one that is so one-sided that it's just that the case should have been resolved as a matter of law in summary judgment, but that it really this dispute needed to be resolved by a fact finder. And it could go either way, right? So if there was a promise here, what's the reliance?
The Shoemakers did not purchase insurance on their home because they thought that the Commonwealth was going to do it.
And is that foreseeable? Again, if there was a promise, is that something that would be foreseeable?
I would say yes.
Why?
No need to have two insurance claims on the home.
Great. Is that reliance reasonable?
Yes, because they needed to have insurance on the home as a part of the mortgage.
Yes, but they could have paid it for it themselves, right?
Yes, but once they received the letter saying that the Commonwealth Bank was going to get insurance on their home, and then they didn't receive the second letter saying that they weren't going to, that there was no reason for them to get their own insurance still.
Right. And so we have, I think we have a promise, maybe, right? Reliance, foreseeable, reasonable, and is there a detriment here?
Yeah, their house burned down.
Okay, so their house burned down, and what as a result?
They lost everything, and they didn't have insurance on it. Exactly,
right? So yes, there's definitely a detriment here, right? So, but all of this has to be kind of resolved by a jury. I do just want to make the observation here at the end of this opinion, like there's a really great discussion here, I think, about the kind of elements of promissory estoppel that the court goes through near the end of its opinion. But at the end of each, I just want to make the observation that at each time it says that the evidence would be sufficient to allow a jury to find that, right? And so that's really what this court is resolving is there sufficient evidence to go to a jury? They're not making their own independent evaluation of the evidence. All right. So with that, I think we will stop